This podcast is sponsored by Murgatroyd, intellectual property attorneys. For more information on today's guest and our company, visit murgatroyd.com/podcasts.
Welcome to the third season of Murgatroyd's Innovation.talks podcasts. We're delighted you've joined us. If you have any questions, please get in touch by email at innovation.talks@murgatroyd.com or via @Murgatroyd on Twitter. Don't forget to subscribe to make sure you don't miss any future episodes. So let's go straight into today's podcast.
Hello, I'm Rebecca Dobson. I'm a senior trademark attorney in Murgatroyd's Southampton office. I'm joined today by Catherine Bonner, who's our director and a patent attorney based here. And today we are talking about how to safeguard confidentiality of your intellectual property. So, Catherine, you must have come across this a few times in your professional experience.
It's a hot topic, one I get asked about a lot, and I hope we can discuss it together today. It's really, really important before you file a patent application that you do not disclose anything outside terms of confidence. It's no good someone coming to you saying, I've got a great idea, please can I file a patent application, if they've already disclosed it on their website or on their LinkedIn page before we filed the patent application. I handle patent applications, design applications. It matters less for design applications, but can still be important. But it's really, really crucial for filing a patent application, and that's where it comes up most often.
Too often people lose their rights as a result of it. So the horse is bolted, is what you're saying.
Yeah, absolutely. And it's such a shame because often it's a great idea. The rights are gone and then you're there trying to tidy up a mess, really. But yes, Rebecca, you're a trademark attorney. Is it as important, as crucial for trademark?
Not quite so for trademarks because you don't have this disclosure element. So you can always file a new trademark application. The problem is normally to do with product launches and things like that when people are trying to do a clearance or making sure that they're not going to spend a lot of money and a lot of time in preparing a brand and a logo and what have you for a new product, just to find that somebody has something that's either identical or confusingly similar is a terminology with trademarks. So sometimes a pre-filing clearance search can help that, and that depends where you're going to be filing, where you're going to be using it and for what goods and services. But it is worthwhile because the nightmare scenario, like your horse that's bolted from the patent application, from a trademark perspective, it's putting a lot of time and effort into a new launch just to discover that actually you're going to have to relaunch it in 6 months' time, having had some very nasty letters and some nasty experiences and possibly some court appearances.
And so that could have happened if, for example, an employee or a disgruntled ex-employee or someone in your area had found out what your mark or your branding was and launched theirs earlier than your planned date. Yeah?
Absolutely. It can be a vicious attack as well as a preemptive attack without just being an innocent misunderstanding. So keeping hold of your IP on that front is equally important, and making sure that employees are under the right terms and conditions, and that everyone is bound by confidentiality and IP is handed on accordingly.
Absolutely. We should talk about the mechanisms now, I think, that you can put in place to avoid any of these scenarios we've talked about. I think it's really important that all employees understand how important confidentiality is, either from a new product that you intend to file a patent application for point of view, or even just a big new brand launch or a new version of an app that's going to be launched. I think it's really important that the employees understand that all of that wow and excitement that will come from a new launch is going to be completely scuppered if it's already been divulged, as I say, someone's Twitter feed or on LinkedIn page or something like that. So
it's very easy when you're very excited about something and an employer is getting very involved in it, which is great and everybody loves that. But equally, you've got to keep that to understand the implications of if that gets in the wrong hands or the wrong territory. It needs to be enjoyed but not put into the wrong field.
Yeah, absolutely. So number one is make sure the terms of employment contracts and all of your discussions with your employees, stress how important confidentiality is. And number two, if you're dealing with outside sources, that could be someone preparing a video for a new launch, or it could be producers or manufacturers or prototype manufacturers, that where necessary, people who are not within the business are bound by terms of confidence. And so you'd need to have a non-disclosure agreement with that party that you were talking about your IP with.
And that can extend if you're, from a trademark perspective, when you're designing a logo, if you've got a particular graphic designer who's working on it, they need to have confidentiality agreements, exclusivity or whatever, because a breach of that could be enormous if you've spent a lot of time and money on a logo and then they just hand it over to another of their clients.
Yeah, guaranteed that graphic designer won't only be working for you. Yeah, absolutely. I think it's also really important that employees, it's not in a dictatorial manner. I think it always works best if it, as you said, an employee can be excited about a new launch or something. So positive employee engagement, understanding why, but also that they're being a great benefit to the company because of keeping confidentiality, keeping everything under wraps.
You need that excitement. That's what keeps a business going, and that's its core elements. But equally, part of its core elements is understanding that growth needs the IP, and the confidentiality is key to keeping that growth and that momentum going.
I should probably say something about patents and confidentiality. It's a bit of a I don't want to bring too much legal jargon in, but from a patent application point of view and an invention point of view, an employee employed by a company, any of their ideas, we're presuming they're kept under terms of confidence anyway, but any of those ideas, anything that might be patentable, in the normal course of their day-to-day work, that is all taken as to be owned by the employer. So all these confidentiality agreements and all of the terms that we've talked about so far, that owned by the employer is nothing to do in a way with the employment contract. That is statute. That is UK patent law. So there does not need to be a specific clause in the employment contract ensuring that the rights to the invention are transferred to the employer. That happens straight away. I don't want anyone to panic thinking that they have to keep everything under wraps from a confidence point of view for the rights to an invention. But as we've said, it is really important for items that may not be protected by a patent application on the soft intellectual property, the brands, the logo, the trademarks that are around that.
So when we've been talking about this in kind of random scenarios and ideas and just having a bit of a chinwag about it, where have you seen this actually happen? Where is it really properly? Where are the dangers that these business owners should actually flag up and really have their alerts on?
Yeah, a good point. As I've said, discussions with prototype manufacturers, other people you're involving in your project, non-disclosure agreements should be in place. But I think there's a lot of other examples that I've seen or that we've had to warn clients and business owners about where there could potentially be a loss of confidentiality, often in a more informal setting where no one would think to have a non-disclosure agreement. So I think trade shows, really a danger there where someone on a trade stand is getting excited, there's a potential sale or engagement with a customer, and there they are getting excited about a new product that's not on the stand, it hasn't been launched yet, but they're disclosing information. I think any meeting that might be happening, potentially with a collaboration or another partner, people can get enthusiastic there and share ideas at an early stage before any non-disclosure agreement has been agreed. I've also, in my time in industry, we've had visits from royalty, which have been terribly exciting, but you'll often get visits where you have someone who's really held in very high regard by the senior members of the leadership team, and that person may not be asked to sign a non-disclosure agreement before they come to visit. So I think it's always there's
it doesn't go with a bunch of flowers as you're meeting the queen then. I'm royalty do sign non-disclosure agreements. But so customer visits, supplier visits, I've had to try and enforce those when a new supplier comes to visit a factory. That supplier will also supply other people, often within the same industry. And so non-disclosure agreements, or at least a discussion under terms of confidence, needs to be had before that takes place. General chat, employees, I think, and people within a business are not in isolation.
They are often have friends outside of work or other colleagues who work in the same sector. And those general chit-chat, I think, needs to be reined in.
And there's a move these days, isn't there, to forums and chat. And it doesn't have to be a physical chat. It doesn't have to be talking to people. It can actually be online. It can be a very innocent exchange of ideas, which is great in many respects. But that final little bit that could give it away is all too close and all too in danger. So sometimes that needs to be kept in check as well, doesn't it?
Absolutely. And I do intellectual property education seminars to a number of clients, and there is on one of my slides, it just says industrial espionage, be on guard, because potentially there are other people who are interested in peering through windows and seeing what you're doing. So They don't necessarily come in strange overcoats with hats and sunglasses and funny moustaches. No, absolutely not. I also think from a security point of view, I think we should all be aware of it, but that tailgating where we're wonderfully British and polite and we hold the door open for the person behind us, does that person have a lanyard on that's got your company logo on? Well, if they don't, what are they doing there? You know, whatever the security system is for that customer. You often find fingerprint entry to certain doors only. Well, that should be enforced. You shouldn't be letting in the person behind you without them scanning their fingerprint. If it appears rude, fine. You can apologise when they come through the door, I think.
It's a bit like the politician walking out of number 10 with his notebook open, isn't it? I mean, it's a rush to get out of a meeting. It's a rush to get a train or whatever. And all of a sudden you've left something that really could be vital. And while that's very Hollywood in many respects, actually, it is reality as well.
Yes, definitely time to be on your guard. There are plenty of places where confidentiality could be compromised. But if you're aware of the risks and you take appropriate steps, then I think you're in a good place to protect it. So overall, what I think we're saying is that there are steps that we can take to safeguard confidentiality. It comes up a lot, but providing I think that you've got non-disclosure agreements in place, you've got an engagement policy with your employees, people know what the stance is on keeping things under wraps, keeping things confidential, then really we should be in a good place to protect intellectual property that a business has. I do think intellectual property and confidentiality policies are really important so that across a whole company, there's a company-wide stance and a policy. People know what to do. I've put those in place before for a number of clients, and we are often asked to advise on that. Sometimes it falls to engineering or head of tech, but sometimes the poor MD gets it. So yeah, we're very happy to help out on that. And as I say, a policy on intellectual property, a policy on confidentiality, I think can be incredibly useful.
Absolutely. It's about people understanding what the dangers are and having a structure to be able to cope with that, and everyone knows where they stand. Great. Well, thank you very much, Catherine, for sharing your extensive experience on safeguarding the confidentiality of intellectual property. It's been very useful, very interesting, and I enjoy repeating on various subjects in the future.
Thank you, Rebecca.
Thanks for your time today. We hope you found today's podcast valuable. And don't forget to subscribe to make sure you don't miss any of our future episodes. So until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our podcasts are topical and informative. We are always looking for suggestions for new topics for discussion, so if there's an area of IP that you're keen to understand better, please drop us a line at innovation.talks@murgatroyd.com.